On April 5th, 2019, Tyler Griffin was involved in a forceful law enforcement encounter with Officer Donald Vickers and Officer Matthew Abad of the Atlanta Police Department in Atlanta, Georgia. The officers followed Mr. Griffin for several blocks in an unmarked vehicle without emergency lighting, citing alleged traffic infractions as the basis for the stop, although the department failed to produce any dash camera footage supporting those allegations. During the investigation, Officer Vickers tackled Mr. Griffin without any appearance of an imminent threat. Mr. Griffin fractured his ankle and was forced to walk on it. Mr. Griffin later brought a federal civil rights action against the individual officers and the city of Atlanta in the U.S. District Court for the Northern District of Georgia. During discovery, plaintiff's counsel Matt Kahn of the Butler Law Firm uncovered inconsistencies within the department's administrative records and requested a formal corporate deposition. On July 22, 2021, Mr. Kahn deposed Officer Vickers to testify about the incident. In total, the deposition lasted nearly 4 hours, so this episode will feature only selected excerpts. If you'd like to watch the testimony in its entirety, you'll find a link to the full proceeding in the description below.
So when you first saw Mr. Griffin, you claimed that he almost hit you head on, right?
That's correct.
Do you have any evidence to prove that?
No, sir.
Was there a
any evidence to prove that?
Was there a dash cam in the vehicle you were driving?
No, sir.
Why not?
That is a undercover vehicle and is not equipped with a dash cam.
So the only proof that you have is your word. Is that right?
My word. Well, let's back up. The only proof that I had that he was coming at me head on, or
Yes,
the whole thing.
The only proof that you have
Okay.
that he was coming at you head on is your word.
That's an ABADS. That's it.
So then I guess more accurately, the only proof you have is the word of 2 officers who are being sued in federal court for police brutality. Is that right?
Objection, but you can answer.
That's correct.
And okay, so we're looking at Plaintiff's Exhibit 30, and my question is do you really think that driving off of a ledge did that to Mr. Griffin's ankle?
Objection, but you can answer.
I think it's very possible.
And what are your qualifications to opine on that?
I don't know if you want to say qualifications or experience, but I've seen a lot of accidents in there. What they can do to a human body is pretty horrific.
But you didn't see this accident, as you call it, did you?
No, I did not physically witness that accident.
So you stayed in the car while ABAD approached Mr. Griffin, is that right?
No, sir, I was not in the car. I was outside the car from trying to secure the vehicle and looking at our location on the road signs and giving it over radio to giving over to the dispatch so that units could, arrive to where we were at. And then I approached.
Okay. And you said that there was a car, the homeowner's car was blocking your view of the bottom of the driveway. That's correct? Is that correct?
I think between the hill, the angle of the vehicle, and yes, the homeowner's car. I think if the homeowner's car was not there, I'd be able to see pretty much the whole encounter with ABAD and the suspect vehicle.
Now, at what point after you left your car did you first see ABAD standing by Mr. Griffin's car?
As I started to approach coming down the driveway between the car and the house.
And could you tell me what you saw when you first saw that?
Oh, well, I saw ABAD getting, I saw and heard ABAD giving orders for Mr. Griffin to get out of the car. ABAD had a control hold on Mr. Griffin. Mr. Griffin swiped ABAD's hand away, and then that's when I ran up and tackled.
And sir, none of that is on video,
Mr. Griffin
right?
was bigger than ABAD looking.
Sir, none of what
Yes.
none of what you saw was on video, right?
If my video didn't catch it, ABAD's did.
So the first time that we see you on video, though, is on Abad's body cam when you lunge toward Mr. Griffin. Is that right?
I believe so.
At what point did you decide to tackle Mr. Griffin?
Once he pushed Abad's hand away.
And why did you decide to tackle Mr. Griffin?
He was obstructing Abad and not obeying his commands. And then once you swipe an officer's hands, you become a threat at that point, and I alleviated it.
Is there anything else that you could have done to get in there?
From the distance I was at, I mean, Monday night quarterbacking, possibly. I wouldn't want to tase. If I missed, then I would hit Abad. Possibly hit Abad. So I went for a tackle.
Did you know that Mr. Griffin's ankle was hurt after you tackled him?
Shortly after, yes, sir.
How shortly after did you realize that Mr. Griffin's ankle was hurt?
That I can't recall.
Stop the car! Stop the car! Stop the car! Stop the car! Get out of the fucking car, Atlanta Police! Get out of the fucking car! Get out the car now! Get out the car.
And Buchanan.
Let's go. Get out of the car. Get out of the car. Let's move. What are you doing, man?
What do you mean, what am I doing?
Tell me, what are you doing?
Wait a minute, hold on. Don't grab me like that.
No, hold on. No, hold on. No, hold on. You do
don't
not
get out.
swipe
You listen.
my hands from me. Do you understand?
You got anybody else in the car? You got any weapons or anybody else? Go check the car.
All right. Do you think that you did anything wrong in Plaintiff's Exhibit 1.2?
No, sir.
Do you think the Atlanta Police Department encourages police officers to act the way that you did in Plaintiff's Exhibit 1.2?
If the situation calls for it, yes.
Do they teach that sort of thing at the police academy?
Objection, but you can answer if you know.
As far as when somebody's obstructing, to take them down as quick as possible to alleviate the threat, yes.
Did Abad do anything to stop you from tackling Mr. Griffin?
No, sir.
If Abad had waved his hand and told you to stop, would you have still tackled Mr. Griffin?
Objection, but you can answer.
What's the basis of that objection? Just so I can cure the question.
Are you asking a fact witness a hypothetical?
What is the basis? I asked you, what is the basis of your objection?
Well, that is the basis of my objection.
So it's an improper hypothetical. That would be the answer to, that would be your objection?
Yes.
Okay. All right. Noted. So sir, I'm going to ask you the question again. If Abad had waved his hand and told you to stop, would you have still tackled Mr. Griffin?
The same objection, but you can answer.
Probably not. Being that there was probably not a threat then. If I felt like Mr. Griffin was still a threat, yes, I would have.
It would have been possible for Abad.
Depends on if I felt like he was a threat.
Sure. It would have been possible for Abad to wave his hand and tell you to stop, right?
Objection, but you can answer.
He'd have to be really fast about it. At that point, Mr. Griffin swiped Abad's hand down towards his side.
If Abad had said,
I don't
"Hey,
know how."
sorry, I didn't realize you were done." If Abad had said, "Hey Vickers, hold up," would you have still tackled Mr. Griffin?
Objection, but you can answer.
Once again, if I felt like there was a threat, yes, I would have.
But if Abad had said, "Hey Vickers, hold up," what reason would you have to believe that there was a threat?
Same objection, but you can answer.
If Abad was able to say that hypothetically, it leads me to believe that there wouldn't be a threat, and I would see that there was no threat, and I probably would not tackle. Well, I wouldn't tackle if there wasn't a threat.
Okay, and it would have been possible for Abad to do that, right?
Objection, but you can answer.
Not in that time span, no, sir. And there was a threat.
Officer Vickers confirmed that he likely would not have stopped if Officer Abad had asked him to hold up before tackling Mr. Griffin. Under the legal standard established in Graham versus Connor, excessive force is evaluated through the Fourth Amendment's objective reasonableness test. This standard weighs the severity of the intrusion on an individual's rights against countervailing governmental interests, specifically examining three key factors: the severity of the alleged crime, whether the suspect poses an immediate safety threat, and whether the suspect is actively resisting or attempting to flee arrest. When explicitly asked under oath whether he committed any wrongdoing during the tackle recorded on Officer Abad's Bodycam, Officer Vickers denied any fault and asserted that the Atlanta Police Department actively trains officers to use rapid physical takedowns to eliminate perceived obstruction or threats. In Lee versus Ferraro, 284 F. 3rd 1188, the court established that applying significant physical force against a non-violent, non-resisting individual stopped for a minor infraction constitutes gratuitous force in violation of the Fourth Amendment. By establishing that officers cannot escalate routine traffic interactions into violent physical encounters against non-threatening individuals, Lee set a binding precedent in this jurisdiction that directly condemns Officer Vickers' conduct. Officers are legally obligated to employ de-escalation tactics when feasible, rather than escalating minor encounters into immediate physical violence. And in this case, it does not seem that Officer Vickers adhered to these legal obligations.
I'm going to show you another video. We're going to look at a clip that's been pre-marked as Plaintiff's Exhibit 1.4.
You're gonna get up. Tuck your leg under you.
I can't move my leg. You guys
Is it broken?
I mean, you guys heard it, but
Tuck it under you and use that to get up.
Did you hear Mr. Griffin say, "I can't move my leg"?
I heard him on the video talking to Abad, yes, sir.
But did you hear him say, "I can't," quote, "I can't move my leg," end quote?
Objection. Just to clarify, are you talking about in the video or today? Or at the date of the incident?
I'm asking him questions about the video.
Okay.
So I'll ask it again, sir. In Plaintiff's Exhibit 1.4, did you hear Mr. Griffin say, quote, "I can't move my leg," end quote?
In the video, I hear that.
Did you hear Abad ask Mr. Griffin if his leg was broken, and Mr. Griffin responded, quote, "I mean, you guys heard it," end quote?
In the video, I hear that, yes, sir.
Now, in the video, did you hear Mr. Griffin slur his words when he said, quote, "I can't move my leg," end quote?
No, sir.
And that's because he was not slurring, right?
That's correct.
And did you hear Mr. Griffin slur his words when he said, quote, "I mean, you guys heard it," quote, end quote?
You asked if I heard him slurring then?
Mm-hmm.
No, sir, I did not hear him slur.
And that's because he was not slurring at that time either. Is that right?
That's correct.
oh shit! Oh my god! Oh my god! Oh my god! Help me, please! Oh god! Oh god! Oh god! Help me, please! Oh! Ooh! Shit! Oh my god! Ah! Ah!
So, sir, the question was, in Plaintiff's Exhibit 4.1, the video that we just watched for a second time, Abad makes Mr. Griffin stand up and walk, correct?
Objection. Asked and answered. You can answer if you have something new to add.
He made Mr. Griffin stand, and I don't know if that was Mr. Griffin, him trying to make Mr. Griffin walk. He made Mr. Griffin stand, and I don't know if he was not sure about the broke or not. But,
Well,
yes, he did
ABAD
stand. I don't know if he was trying to make him walk.
Sure. Well, I guess let's break it down. In that video that we just watched, ABAD was standing behind Mr. Griffin, correct?
Beside him, but yes.
And Officer
Side behind. Yes.
And Officer ABAD was urging Mr. Griffin to walk forward, correct?
That's correct.
Okay. Now, it looked like in that video that Mr. Griffin was in pain, didn't it?
Yes, sir.
Now, did you call an ambulance after it was clear that Mr. Griffin couldn't walk?
No.
Did any of the
Like
other
I said before, it was determined that us getting him.
Did any of the other police officers call an ambulance?
I don't know that a 4 was called. I don't think they did. No, sir.
Okay. Well, do you think ABAD did anything wrong in the video we just watched?
No, sir.
So it was okay for ABAD to make a seriously injured citizen walk around on a broken ankle?
Objection, but you can answer.
I don't know if ABAD was trying to make him cause further injury to Mr. Griffin. I don't know what ABAD was thinking. It's about to tell me my computer's about to cut off for some reason. This computer may cut off. If it does, I'll join right back as soon as I figure out what's going on with it.
So I'm gonna ask that question one more time just to get a clear answer for the record. So in your opinion, it was okay for ABAD to make a seriously injured citizen walk around on a broken ankle?
Objection, but you can answer.
It would not be okay to make Mr. Griffin walk on a hurt ankle.
Mr. Kahn questioned Officer Vickers on whether he or any other officer called an ambulance after it became clear that Mr. Griffin was severely injured and unable to walk. Under the 14th Amendment's Due Process Clause and Atlanta Police Department Standard Operating Procedures, police officers owe an affirmative constitutional duty to immediately provide or request emergency medical attention whenever a detainee exhibits an objectively serious medical need or obvious physical trauma. In the video exhibits, Mr. Griffin displayed unmistakable signs of severe injury, yet Officers Abad and Vickers ignored his clear distress and forced him to bear weight on a broken ankle. When Mr. Kahn asked Officer Vickers whether Mr. Griffin was slurring his words when communicating his injury, Officer Vickers admitted under oath that Mr. Griffin was not slurring at all. Under the First Amendment, it strictly protects a citizen's right to verbally question or challenge police officers without facing retaliatory violence or punishment. Grounding his cross-examination in this fundamental protection, Mr. Kahn directed his line of questioning toward establishing that the officers acted out of perceived contempt of authority. Even under the guise of an arrest for obstruction of law enforcement under Official Code of Georgia, annotated 16.10.24, established constitutional jurisprudence strictly prohibits police officers from deploying physical force or withholding emergency medical aid as unlawful retaliation against a citizen for exercising First Amendment speech. In this situation, Mr. Kahn's legal strategy was to establish that Mr. Griffin was articulate, coherent, and cooperative, proving that the officers had no justification to dismiss his injury or force him to walk.
Where Plaintiff's Exhibit 42 summarizes what you told Investigator Nixon, and it says, quote, for whatever reason, it wasn't operating the way it should have, or I don't know. And that's right there.
Yes, sir. I see it.
And I read that correctly?
Yes, sir.
So then you told Investigator Nixon that your body camera wasn't working, right?
Yes, sir. I don't know if it was, like I said before, I don't know if it was a user error or if it was a camera malfunction.
Well, we know for a fact that it was not a camera malfunction, don't we?
Objection, but you can answer if you
no,
know.
Sir.
Excuse,
No, sir.
we do not know that.
I don't know that, sir. That was an old camera. To go further into it, that was an old camera. There's a switch at the top. There's been many complaints with the old camera that the switch was easy to turn off and on. I don't know if I kept hitting it. I don't know. Or I don't know if it was a camera itself that was messed up.
All right. Can you see the screen, my screen, Plaintiff's Exhibit 42, sir?
Yes, sir.
You see where it says, quote, a diagnostic evaluation of the BWC issued to SPO Vickers at the time of this incident does not indicate that the device suffered any type of malfunction or failure or malfunction attributed to anything other than the failure of the operator to properly activate the device. SPO Vickers did not report any issues about his camera at the time or immediately after this incident occurred. Did I read that correctly, sir?
Yes, sir.
So isn't it true then, sir, that we know for a fact that there was no malfunction with the camera, the body camera?
Objection,
Once
but you can
again.
answer if you know.
No, sir, we don't know. I did make issues about the camera not working. I can't tell you exactly when that was made, but also I can tell you, like I said, sometimes, and I guess it's possible that my camera could have been one of them as well, the on and off button were easy to get hit and switched on and off. It could be done accidentally. I don't know, sir.
Is it your testimony that you just don't remember you don't remember at what point you realized that the camera was off and tried to turn it on?
No, sir, I don't remember the exact point. No, sir.
Is it unusual for police officers to turn off their body camera in the middle of an arrest?
Objection,
No.
but you can, I'm sorry, you can answer if you know.
With current policy, no, sir. I mean, you're not supposed to.
So I know you're not supposed to. The question is it unusual for police officers to turn off their body camera in the middle of an arrest?
Same objection, but you can answer.
There has to be some reason for it, sir.
Well, is that something that happens frequently in the Atlanta Police Department?
Not that I
Objection.
know of.
Isn't the point of the body camera so it captures the entire event?
For the most part, yes, sir.
Have you ever heard of police officers turning off their body camera after the use of force to get their stories straight with each other?
You cut out a little bit.
Sure.
Can you repeat that?
I can. The question was, have you ever heard of police officers turning off their body cam after the use of force in order to get their story straight with each other?
After the incident, not to get their story straight, but just to corroborate everything that took place and add everything together.
So it is common then for police officers to turn their body camera off and talk about the use of force at the scene of the arrest.
Objection, but you can answer if you know.
Only after the incident's over, sir.
Officer Vickers denied that officers deactivated their cameras to get their stories straight, claiming instead that they turned them off after an incident to collaborate on everything that took place. Under Standard Police Department Policy, APD.SOP.3133, law enforcement officers are required to keep their body-worn cameras activated at all times during calls for service and enforcement encounters. Because Officer Vickers' camera was not recording during the tackle, Mr. Khan pressed whether the officer had manually deactivated or intentionally failed to activate the device. Under Official Code of Georgia, annotated 24.14.22, Georgia's statutory rule on spoliation, the intentional suppression or failure to preserve critical video evidence permits a judge or jury to draw an adverse inference that the unrecorded footage would have been damaging to the officer. Under Official Code of Georgia, annotated 16.10.20, Georgia law strictly prohibits knowingly making false statements or concealing material facts in any governmental matter. Leveraging this statute alongside perjury standards, Mr. Khan laid the groundwork to expose Officer Vickers' dishonesty. While Officer Vickers claimed under oath to Investigator Nixon that his body camera suffered a technical malfunction, the department's official diagnostic evaluation conclusively established that the hardware experienced zero technical defects or operational failures. By contrasting Officer Vickers' sworn statements against forensic diagnostic proof, Mr. Khan proved that the officer made a knowingly false material statement, confirming intentional manual deactivation and severely damaging his credibility as a witness.
about 60 pages of documents that the city produced to us last night, a few hours before your deposition. And so all these documents relate to Willie Thurmond, who I believe is the individual that you have been talking about.
Okay. Yeah, that's what I was talking about. Yes, sir, I apologize.
So we'll go. I've got some follow-up questions on that, and we'll go through those, and then we'll go back to the other one since you already started talking about it. So obviously you recall the incident. You told me what happened. When Mr. Thurman ran into the door, or was pushed into the door, however you want to call it, was he handcuffed?
Yes, sir.
All right, I'm gonna flip to page 8 in this document. So we're looking at page 8 of Plaintiff's Exhibit A, which appears to be a notice of final adverse action, suggesting a 2-day suspension. Do you agree with that?
Oh, I disagree. I'm fighting that.
Oh, I'm sorry. I mean, is that what this document appears to be?
Yeah, yes, that's the document. Yes.
And so, as I understand it, you have not, in fact, been suspended for this alleged violation.
No, I was suspended. The chief at the time over our unit, even though there was no investigation done, by the time they did an investigation, the camera feed they waited way past 14 days to go do any kind of pickup of the surveillance. They didn't talk to any witnesses. They didn't get statements for anybody. He said, just go ahead and give them the 2 days and let me fight it in the civilian review.
Okay,
So
you were
so
you were found to have used excessive force and suspended for that. Is that right?
Yes.
And then you're in the process of fighting it on the back end. Is that correct? That's correct.
that's correct.
Look at page 14. So this is another what appears to be another final adverse action related to the same incident, but it says not sustained. Have you ever seen this?
I don't think so, sir.
So you don't have any idea which of the ones that we just looked at is the actual final notice?
And what I'm thinking is Internal Affairs, OPS, they sent it up as not sustained, but when it hit the chief's desk, he changed it.
I see. All right, I'm gonna flip to page 19 here. Do you see the highlighted text on this document, which is Bates label 001059, that says, quote, after reviewing the above mentioned OPS investigative file involving Officer Vickers, I do not agree with the sustaining of work rule 4.2.33.
Yes, sir.
So again, I want to ask this again. I asked you earlier, would you say it's normal? It's a normal occurrence for a higher ranking officer to recommend that an OPS finding be changed from sustained to not sustained or exonerated?
Objection, but you can answer if you know.
Like I said, it's to the best of my knowledge, it's up to OPS to do their part of the investigation. And it gets forwarded up to their chain of command. Their chain of command is supposed to look it over and agree or disagree with it, and then have their ruling. And like in this chain of command, the major disagreed with OPS.
So OPS serves as an independent body to investigate police misconduct, right?
I'm sorry, can you say it again?
Sure. Would you agree that OPS serves as an independent body to investigate police misconduct, among other things?
Yes, sir, I do.
So why is it okay for someone who works directly with an officer to change a finding of an independent OPS investigation?
Objection, but you can answer if you know.
Um, so I can't really answer your question because these are all higher ups. That's my major. He has an office of his own. The people that work directly underneath him are the captains, the lieutenants, and the sergeants. I'm right at the bottom of the totem pole. This was a letter that it looks like he sent after OPS said not sustained. The chief came back and said, no, go ahead and sustain it. And the major, after looking at it, who has a lot of investigative experience, wrote a letter back.
Okay.
But obviously, they're doing good with the chief. So,
Would you agree that the practice of allowing City of Atlanta employees outside of OPS to change the final disposition of an investigation leaves room for police officers to sort of look out for their own?
no, sir. This chain of command, they're all appointed. They're all appointed positions. OPS, they have their chain of command as well, and then it goes up.
But this isn't the first time that we've seen a document with a higher up recommending that one of your excessive force violations be changed to not sustained, is it?
Objection. I don't think that this was an excessive force violation, and it even said so in the document.
Okay, your objection is noted. Officer Vickers, if you'd like to answer the question, you're free to do so.
Can you ask a question again?
This isn't the first document that we've seen recommending one of your violations involving excessive force be changed from not sustained, be changed from sustained to not sustained, is it?
Same objection, but you can answer.
Yeah, I mean, you could say that the chain of command changes some of the rulings sometimes.
What's the point of OPS if the chain of command can just overturn it after an investigation?
It's really not for me to answer that, but to the best of my knowledge, it's no different than you have an investigator and then they have their chain of command. You have an investigator, sorry, I said unstable. I don't know if you can hear me or not. You have investigators and they have their chain of command. The investigators come up with it and their supervisors have to okay it. Hey, I agree with the findings. I don't agree with the findings. Hey, why didn't you do this? Why didn't you do that? You know, so, I mean, that's all I can answer your question.
Officer Vickers states that he does not agree with Mr. Khan's claim that this situation represents officers looking out for one another. The case referenced involved a May 2017 incident at Grady Detention, where Officer Vickers was accused of pushing a handcuffed detainee, Willie Thurmond, into a doorway, causing him to lose consciousness. Through this inquiry, Mr. Khan sought to establish a pattern of prior officer misconduct alongside a routine practice of command-level overrides in internal disciplinary matters. This strategy is critical for establishing municipal liability under Monell versus Department of Social Services, which dictates that a city cannot be held liable simply for an employee's actions, but can be held liable if an unwritten policy, informal custom, or deliberate failure to discipline officers causes a constitutional violation. To support this Monell theory, Mr. Khan pointed out that Major Hampton sent an internal memorandum to Deputy Chief Glazer formally disagreeing with the Office of Professional Standards recommendation to sustain a violation of Work Rule 4.2.33 and APD SOP 3030/2.2 against Officer Vickers. In doing so, Mr. Khan was referencing the blue wall of silence, an unwritten informal code within law enforcement where officers protect their peers from internal discipline or legal liability. Finally, Officer Vickers reiterated that he cannot speak on behalf of his superiors to explain their administrative decisions or why Major Hampton contested the disciplinary finding, noting that as an officer at the bottom of the chain of command, such high-level determinations rest entirely with leadership. After that, the deposition continued for a few more hours. In February 2022, Judge Thomas Thrash ruled that neither particular officer was entitled to summary judgment on the constitutional claims arising from this incident. The court allowed the excessive force and failure to intervene claims to proceed to a jury trial while dismissing the remaining municipal liability claims under a federal court order. The court's findings further described the events surrounding the arrest, stating that the officers followed Mr. Griffin in an unmarked vehicle without activating police sirens, drew a service weapon while issuing verbal commands before identifying themselves as law enforcement, and required Mr. Griffin walked on a severely fractured ankle despite repeated warnings that he was seriously injured. Separate from the federal civil litigation, Officer Vickers was indicted by a Fulton County grand jury on 2 felony charges, aggravated battery and violation of oath of office. The indictment resulted in his immediate removal from duty and the initiation of criminal proceedings against him. After the court denied qualified immunity, the remaining civil claims advanced against the officers individually, meaning that any damages awarded would be the personal responsibility of the defendants rather than being paid with public funds. This deposition illustrates systemic issues surrounding police liability, institutional accountability, and mutual protection among police officers. During his deposition, Officer Vickers refused to accept any accountability for his use of excessive force, alleging that Mr. Griffin posed an immediate threat to Officer Abad. Mr. Khan, on the other hand, countered this claim by proving Mr. Griffin was standing still and citing APD's own instructors, who testified under oath that the tackle was unjustified. By presenting technical audits proving that Officer Vickers' body camera was deactivated due to user error rather than any mechanical failure, Mr. Khan sought to dismantle the officer's credibility and expose an intentional attempt to conceal the incident. Even when Internal Affairs recommended disciplinary suspensions for prior misconduct, Major Hampton overruled those findings, reinforcing Mr. Khan's argument that departmental leadership actively protects officers from accountability. If you want to watch more of this case, this video shows Sergeant Quentin Reese deposition, who was designated as the official representative for the city of Atlanta in this civil lawsuit.